Right. There's a distinct challenge in being the fourth of four lawyers to speak, and that challenge is, will anything be left to say? Put it this way, a lot of my prepared remarks have sort of gone under the bus in the course of the last three presentations. So I will attempt to address the paper that actually appears in the materials, but I'll abuse the fact of having a captive audience to sort of become something of a commentator ahead of the actual discussant. So let me start with a few observations about the award, which I think are useful and haven't yet been made. I want to make 3 points drawing from the work of Benedict Kingsbury. I want to talk briefly about the Tribunal's composition and approach, and then I want to touch on a couple of issues of significance that I think more could be taken out of. I'll then turn briefly to my actual prepared paper and perhaps conclude with some reflections, time permitting. So Benedict Kingsbury makes a number of points about compulsory dispute settlement in a treaty system that I think are useful. And the first is that Articles 31 and 32 of the Vienna Convention on the Law of Treaties can be deceptive. They give us the idea there is one law of treaty interpretation. Okay, the rules set out in Articles 31 and 32 are broad and flexible, and actually what any judicial settlement body is doing in international law is addressing a particular community of experts. Treaty interpretation as understood at the World Trade Organization is not treaty interpretation as understood in the International Tribunal for the Law of the Sea. They deal with different principal instruments, they deal with different subgroups of the invisible College of International Lawyers. So one question to ask in the award is, who was the Tribunal speaking to beyond the immediate parties? And in part, they were speaking to a long-established community of Law of the Sea scholars, and I think trying to push, in some ways quite hard, the shape of future Law of the Sea scholarship and dispute settlement. Secondly, why would states agree to have compulsory dispute settlement in a major treaty? Okay, it's an unusual feature of international relations, and a lot of IR scholars are against the idea of compulsory dispute settlement. They say unless both parties buy in, you're not going to get a decent result. And Kingsbury puts the point that in major multilateral negotiations, small states require some assurance that the promises of great powers are credible. Okay, and a compulsory dispute settlement clause serves as a kind of placeholder for that. But what do small states expect to get out of it? And again, Kingsbury's point is they don't expect magical compliance with awards. What they expect is the prospect of other states and larger powers rallying to their cause when there's been a normative determination as to rights and obligations. Okay, so those are my observations from Kingsbury. Let me turn briefly to the Tribunal, because we've spoken a bit about the mechanics of the composition so far and China's missed opportunity to appoint an arbitrator who would have then participated in the composition of the rest of the Tribunal. So in effect, all the vacancies were filled after the Philippines appointed its initial arbitrator, Judge Wolfram, the Austrian judge of ITLOS. All the vacancies were filled by the president of the Law of the Sea Tribunal when the clock ran out on various procedural limits. And who did he fill it with? Well, the final, the president of the Arbitral Tribunal was Judge Thomas Mensah, the enormously distinguished Ghanaian diplomat and jurist who was one of the earliest commentators on the new Law of the Sea Convention and spent many years working at the IMO before being the first president of ITLOS. Rudiger Wolfram, a heavyweight, a radical in some ways in Law of the Sea scholarship, an undoubted superstar of his field. Fred Soons, an incredibly well-respected academic. Judge Jean-Pierre Cotte, a highly experienced French judge of the Law of the Sea Tribunal, and Judge Pawlak of Poland, whose scholarship I don't know well because I don't read Polish, but certainly seems to be extensive if you look at his CV. So these were heavyweights, and they were unanimous. Okay, so that says something about the force of the award. Now, what were the issues of significance? We've touched on a number of them, but I just want to briefly skate over three. I think a major theme, actually, in the award that we haven't spoken about of general significance is how compulsory is compulsory dispute settlement? Okay, because prior to this award, in my view, the ordinary view of scholarship was UNCLOS dispute settlement is only compulsory and comprehensive as a weak starting proposition. There are too many carve-outs, either automatic or optional, in the jurisdictional system. So the view 15, 20 years ago was that this was a weak dispute settlement system that might never amount to much because the carve-outs were too big. This award, I think, takes as its starting interpretive principle compulsory means compulsory and comprehensive means comprehensive, and the exceptions and qualifications are to be construed narrowly, not liberally. And that, I would suggest, signals a fundamental shift if it's taken up by other tribunals. And let's remember that, you know, at least 3 of these judges are going back to sit on ITLOS. Also, the issue of classification of islands, I think, just to draw it right out in the open, they fired an enormous shot across the bows in saying that Ituaba is not an island. If Ituaba is not an island, then, you know, basically nothing in dispute in the South China Seas is, and that clarifies things quite stringently. But why did they take that approach? And I think part of the approach here draws on a different reading of the history of the negotiations. They said the point of giving EEZs to islands was that communities who were dependent for their life on the island should benefit equally from the new regime of EEZs. The point of it was not to give random windfalls to major powers that happened to have rocks that were geographically luckily distributed. Okay, so there's a different reading there of the history of the convention. Also, the other thing we haven't remarked on is it's not drawn right out in the open, but they do make the point that there's been a violation of Article 300. That's the duty to act in good faith. No international court or tribunal that I'm aware of in the course of the 19th or 20th century has ever found a state, let alone a major power, to have acted in bad faith. Because you can't act in bad faith without breaching a substantive obligation first. So why not just stop at the breach of the substantive obligation rather than go on and basically actively impugn, as it were, the honour of a state? But the tribunal found that the actions of continued island building while a dispute was on foot constituted actions in active bad faith. That is quite extraordinary. So this was a tribunal that went, I think for a number of reasons, well beyond what any commentator was expecting. All right, so the paper I was asked to prepare, which I'll dispense with as quickly as I can, was essentially to ask, well, you know, are there any mechanisms such as joint development zones or provisional arrangements of practical nature that might help de-escalate the conflict and get resource management on a useful footing? The essential conclusion of my paper is it's theoretically possible but unlikely. The odds of provisional arrangements are effectively nil because they are predicated, just to back up, Articles 74 and 83 of the Law of the Sea Convention impose upon states a duty to seek to enter provisional arrangements of a practical nature pending final delimitation, right? To avoid resources going underutilised or to avoid impeding economic development. The difficulty is Articles 74 and 83 presume there's something to delimit. Okay? The effect of the award is that by and large there is nothing to delimit. So why would the Philippines or Vietnam or other claimant states proceed under Article 74 or 83? It's incredibly unlikely because it would implicitly concede there is something to delimit. And based on the determination of islands, there simply is not. So the question then is, how do we get away from, if we want to see active cooperation, particularly in fisheries, which has been a common theme, how do we get away from the exclusive language of sovereignty and rights towards some kind of cooperative framework? And the traditional answer would be, well, could we get there through some kind of fisheries management organisation, right? Focus not on where things are happening, the zonal approach, but what we're trying to regulate, sustainable fishing, the activity-based approach. And we've touched on this already in some of the presentations, so I'll just briefly sketch at a high level what you might aim to achieve and then the practical obstacles. So ideally in a fisheries management organisation, you agree on commonly applicable rules irrespective of the area in which they are to be applied. That's the essence of it. And you may even be able to circumvent some difficult political questions about whether a fisheries management organisation is directly binding you in a way that compromises your sovereignty by using language such as, you know, the state parties agree to implement the recommendations of the Commission. Some of the clauses of the Japan-Korea Joint Fisheries Management Zone Agreement use that sort of language to kind of get around certain sovereignty questions. So that's not impossible, but it doesn't carry us very far if we're looking for a legal hook. As we noted before, Article 123 of the Law of the Sea Convention encourages states to coordinate their actions through an appropriate regional organisation in the case of the semi-enclosed sea. And I'll come back to that question of what the appropriate organisation might be. But that is merely an exhortatory provision. If we look at the actual provisions of the Law of the Sea Convention on fisheries management, yes, we do have Article 63 on straddling stocks, so stocks that either occur in adjacent, straddle adjacent EEZs or an EEZ and a high seas area. But the only active duty placed upon states under Article 63 in respect of straddling stocks is one of negotiation. You can proceed to set up an RFMO, but that's only an alternative to direct negotiation. The only provision of the Law of the Sea Convention that actively imposes a duty upon states to participate in the work of a regional fisheries management organisation is Article 64 on highly migratory stocks, but that has a limited subject matter. It has to be a highly migratory species listed in Annex I of the Convention. So while there is a duty to establish or participate in the work of an existing Fisheries Commission, we then come to the question of, is there an existing Fisheries Commission? Well, technically, the Food and Agriculture Organisation's Asia-Pacific Fishery Commission is already active in this area, and one could argue it's the competent organisation. There's also no duty upon fisheries management organisations to adopt particularly stringent measures. They may simply adopt non-binding recommendations. They might conduct scientific studies. Now, some of those gaps in the law of fisheries management organisations were designed to be plugged by the UN Fish Stocks Agreement, which did specify certain minimum enforcement provisions if regional fisheries management organisations didn't implement them themselves. But the Fish Stocks Agreement only binds the parties to it. And, for example, in the present context, neither China nor Malaysia nor Vietnam is a party to the Fish Stocks Agreement. So really, all we at the end of the day, all one can say is that the law can frame cooperation, it can't force it, and it's hard to identify a compelling legal argument that a particular type of regional fisheries management organisation needs to be set up. All right, what do we get, moving back to the case and sort of broader reflections, what do we get out of the case? Just a couple of things I'd like to highlight. One thing is, and this is just a different way of framing a point that's already been made. So the sort of law school concept of legal method is you identify the facts that are relevant to a dispute, apply the applicable law, and mechanically produce a result. What that omits is the application of law to facts changes the facts, right? When a court says you no longer own a house or you are divorced, the facts of your social reality have changed. Law changes the facts, and that's one of the things that the Philippines has achieved. Also, there's the question of, well, what other, the question was asked earlier, could other claimant states bring cases? And so the point was made, Indonesia, for example, is not a claimant state. It would not have a case to bring. I dispute that, at least at the level of a hypothetical. To the extent that China is interfering in Chinese national vessels are illegally fishing in Indonesian waters, for example, there is a case that, as a flag state, it has a duty to prevent that. That point is made in this award. Interference in other states' zones is now a way of circumventing sovereignty disputes. It's the mechanism that will probably be used to bring the case by the Ukraine against Russia regarding Crimean Sea. The argument will be not about sovereignty, but about interference with zonal entitlements. How does this play into broader debates? I just sort of say that we've raised a couple of times the question of rule of law versus rules-based order. And I would agree with Professor Scott's very apt observation that a rules-based order often sounds rather weaker than the rule of law. But there is something intriguing here where China, as a party to the Law of the Sea Convention, is arguing it's not binding, while the United States, as a non-party to the convention, is arguing everyone needs to respect it. But at the end of the day, when you get an award in this sort of system, the point I'd make is the struggle is not for enforcement. International law is a decentralised system without centralised enforcement. That's just a fact of the system. So the question is not, the struggle isn't for enforcement, but for the legitimacy of one's position. And in that sense, the Philippines has won a very substantial victory. We've also mentioned the progressive development of international law, and I'd say here that on a number of points, such as the definition of islands, we can envisage in the Harold Coe sense, or the Anne-Marie Slaughter sense, the work of the tribunal here as being that of norm entrepreneurs. They haven't gone out and made new law out of nothing. It's certainly a defensible interpretation of the convention. But what remains to be seen is whether it attracts the kind of consensus from the Invisible College of International Lawyers that this is the approach that will be taken in future. So this is, as it were, the first step in a lawmaking or law interpreting process, and it's not necessarily concluded. And finally, I think this case shows as a whole that the UNCLOS dispute settlement system is less constrained than was presumed 10 or 15 years ago. There are attractive litigation strategies available, and the two key features to bear in mind are this sort of fairly firm statement from the tribunal, in effect, that compulsory means compulsory. That's attractive. And 166 states are parties to the Law of the Sea Convention. That gives this a reach as a dispute settlement mechanism that is unparalleled, in my view, outside the World Trade Organization. And therefore, we can probably expect to see more, not less, Law of the Sea litigation in future. Thank you.